Why would a licensor resist placing their source code in escrow for the benefit of a licensee in a commercial transaction? It seems a simple enough, straightforward idea that the licensee may have a desire to support itself only in the event that the licensor is unwilling or unavailable to do so, and the licensee would need the source code in order to be able to provide that support for itself. Why resist? Well, the truth is there are an array of reasons that licensors have concerns about entering into source code escrow agreements, and these reasons vary from licensor to licensor, and they vary from transaction to transaction within a single company, but I would describe them in four basic categories. One is a simple matter of cost, of course. It does cost something to place source code in escrow, but it is on the order of a few $1,000s a year for any given product. If there are a lot of licensees who are named as beneficiaries for a given product's escrow deposit, it may run into some significant expense. And so licensors are reluctant to start an escrow program due to cost, although that can be shared with licensees, for example. But cost is an issue, but another is simply the operational difficulty. If a licensor does not have an escrow program in place, it does cause a need to create practices, internal practices, where persons are tasked with the responsibility of tracking changes to code and updates and ensuring that the code that is deposited into the escrow account is up to date and is the appropriate code for the licensee, what's been promised to be placed in escrow. And remember, it's not just code that is placed in the escrow, but perhaps other materials that are needed by the licensee in order to make use of that source code should it be released from escrow. So there is some operational burden associated with that. But far and away, the biggest reason to resist is the concern that release of the source code will endanger the trade secret protection that the licensor holds with respect to the source code. Source code for software is not ordinarily made public in commercial software arrangements, and so how problems have been attacked through the algorithms that are in that source code remains a trade secret for the licensor. Let's be clear, release of the source code to the licensee does not necessarily undermine the trade secret protection so long as it remains confidential. If the licensee remains subject to confidentiality obligations, then it needn't evaporate the trade secret protections that already exist. So there is a concern about trade secrets, but those can ordinarily be managed. It depends on the licensee and the licensor's assessment of the licensee's willingness and ability to protect that confidentiality, but there is always that trade secret concern. And then finally, there is the concern, of course, of support for the licensee. Just because source code is released from escrow to the licensee doesn't mean that there are no further support obligations, or it doesn't necessarily mean that. It may be the case that the licensor has ongoing obligations to provide technical support to the licensee and perhaps even ongoing obligations to provide code maintenance. If a licensee has received source code from an escrow release, has modified that or created derivative works, or has integrated that with the licensee's own software and systems, that creates an additional support burden, or can create a more difficult support burden for a licensor. And so a licensor would be reluctant to be on the hook for support of those code creations that it has not created itself. And so a licensor will want to be certain that those issues are addressed in any escrow agreement or any license agreement that contemplates escrow. So there are an array of reasons to resist that include cost and the operational burden, the trade secret jeopardy that may be caused, and then of course the additional support burdens that can be created by the relationship. Therefore, licensors do have concerns that are legitimate and need to be taken into consideration whenever an escrow relationship is created.